I want to pursue Justice Barrett's line of questioning just a little bit further, because you do rewrite the confession in a way that refers to no other person at all. And I wonder, does that implicate your co-defendant's due process right to be able to say somebody else did it? And pointing a finger at somebody else is an important right of that defendant, too. You would eliminate that. And so it does seem to me that that drives to just exactly what Justice Barrett's suggesting, that in order to balance the rights of both of these defendants, if there's only two, you're always going to have to sever. What's wrong with that?
I think that there could be cases, and I believe the government cites one such lower court case in its brief, where the manner of redaction could affect the rights of the confessing defendant. And that could be where...
No, how could you possibly redact when there's only one other person potentially involved?
Well, but I don't think that that is true, for instance, on the facts of this case. Now, just to be
clear...
Show
me how. Tell me how.
So
how would you redact it without...
As we explain in our reply brief, what the government could have done is to have limited the agent's testimony to Stillwell's statements that he went to the Philippines, participated in the murder while he was there, and received payment for his role in the murder.
Again, it eliminates any reference to any other person's involvement, and that implicates the other defendant's due process rights. I'm going to just try one more time. Have you got any other way you could redact other than the way you suggest in your reply brief? Maybe that's another way of getting at the same question.
So I'm not sure exactly how it would have affected Stillwell's due process rights in this instance.
I'm pretty sure he would have raised that objection, aren't you?
But I'm not sure that it would have been a valid objection, Justice Gorsuch, because it's not entirely clear to me how that would compromise any of his defenses. And I would note that this is a rather artificial discussion here, because Stillwell, like Hunter, the other defendant in this case, effectively conceded his involvement in the murder.
Sure.
His sole defense in this case was the jurisdictional defense that there was not a sufficient nexus to the United States.
You have, just to put a pin on it, you don't have another way to rewrite this confession.
Well, it would be open to the government to come up with an alternative manner of redaction that does not make it likely that the jury would draw the inference that the other person is the non-confessing defendant.
I'm going to take
There are any number of ways in which the gist of what I said could be communicated, but the key point is that the reference to the other person would have to be removed. Now, I would also add one thing.
So that is a no, then.
Well, I would add one thing, though, which is an important caveat. One of the alternatives that is available to the government is to introduce confessions, but to use them in a manner that does not create the inference. And as we point out in this case, there were two things that
Can I ask
took place.
a separate line of questioning? I'm sorry. And I think we've got the answer. We've exhausted that one. Isn't there some oddity about the fact that we think limiting instructions are enough when the defendant himself offers a confession, non-Mirandized confession, Harris, and it's used for impeachment purposes, and we tell the jury, you only consider it for impeachment purposes, and we treat them as competent to respect that line, even though that's probably the most powerful evidence you could possibly have in a confession by the defendant himself. And none of this applies. That's point one. Point two is none of this applies in a bench trial. We assume judges can take all this evidence. No confrontation problem arises, we're told. Judges are capable of respecting this line, but jurors somehow we treat them as lesser able. I don't know. You go to 3 years law school and you're able to follow rules that 12 jurors aren't able to follow?
So I think I would say two things in response to that, Justice Gorsuch. The first is that this court and lower court jurists have long recognized that this is a distinct context, because what you are asking the jury to do is to consider confessions, which have long been understood to be the most powerful form of evidence, as substantive evidence of guilt as to one defendant, but not another. And
why is it different than the Miranda context with the defendant's own words, his own confession, and we say, you can only consider that for impeachment purposes?
Yes,
put it out of your mind with respect to guilt or innocence.
But not as substantive evidence of guilt. And I think
yes, I understand that. Why is that a difference that matters?
I think because the prejudice in this context is so acute. And that is nothing novel in the law. Jurists such as Judge Hand,
Is there any,
Judge
that's
Friendly,
a functionalist argument that jurors can't put this out of their mind, but they can put non-Mirandized confessions out of their mind. Do we have any social science to back that up, that distinction, that one is more impossible for a person to put out of his mind than the other?
This Court has long recognized that there are certain circumstances in which juries cannot be expected to perform that task. And it's not just the context of Bruton. In Jackson versus Deno, this Court invalidated a Texas rule under which the jury was to consider the voluntariness of a confession, and the Court concluded that the problem with that rule is that a jury, once it concluded that a confession was involuntary, would not be able to put it out of its mind. And I would actually point all the way back to this Court's decision in Shepard versus United States, in which Justice Cardozo, writing for the Court, said the same thing with regard to an instruction concerning a dying declaration, that that could not be admitted even with a limiting instruction solely as evidence of the dying declarant's state of mind.
Mr.